And we are recording. This is the Sunshine Ordinance Task Force Complaint Committee of November 16, 2021. I have the time at 5:36. This is a remote regular meeting. Listen public call-in phone number 415-906-4659. Meeting identification 292-783-036#. If you wish to make a statement during general public comment, please press *6 and unmute your telephone to speak. Please press *6 to mute your telephone once you are done with your statement. Remote access to information and participation. In accordance with Governor Newsom's Executive Order N3320, declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London and Breed's proclamation declaring a local emergency issued on February 25th, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health Officer, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely via Microsoft Teams and will allow remote public comment via teleconference. Members of the public may participate by phone or may submit their comments by email to cheryl.leger@sfgov.org. All comments received will be made a part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are made available at sfbos.org/sunshine. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process. Chair Schmidt, would you like to read meeting decorum?
Sure, that's fine. Meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and or menacing behavior may be asked to leave.
Okay. Item number 1, roll call and agenda changes. Let's call the roll. Member Stein?
Here.
Member Stein present. Member Yankee?
Present.
Member Yankee present. Chair Schmidt?
Present.
Chair Schmidt present. We have a quorum. Shall I read item number 2, Chair Schmidt?
Yes, I don't think there are any agenda changes.
Yeah,
I know a couple cases fell off, but no
Yeah,
other changes.
no other changes. Member Stein, do you have any changes?
Yeah, I had a couple changes. So,
The agenda?
yeah, oh, to the agenda? Sorry, no. Only
Okay.
to the, yeah.
Yeah. Only to the minutes. You wanted to get to the minutes. Is that it?
Sorry, yeah. I'm reading my notes. So yeah, if we're still on the agenda, I'm good to wait.
Yeah. Okay. No changes. All right. Shall I read item number 2?
Yes, please.
Item number 2, approval of the October 19, 2021 Complaint Committee meeting minutes. So I have a copy of the minutes. Do we have suggested changes?
Sounds like we may have some edits. Go ahead, Member Stein.
Yeah, so item number 4 should say, and I haven't opened those minutes in front of me yet, but it should say also the person making the request was party to the original request rather than what
Wait
is
a minute.
there. So
Where
sorry.
are you saying
Let me
this?
open the minutes so I can find it. Hold on a second. Item number 4. So under the action, the last line under the action, it says, although the party may be related to the original request. I think it should say also the person making the request was party to the original request.
No, he wasn't.
Well, had submitted documentation in the original request.
Okay, I never saw this person submit documentation in Chris Core's matter.
I think they did. So I don't know how to word this then, but that person was making arguments in the first case as well. And there was like a letter from them in that case.
You'd say it was involved in supporting the initial request.
Maybe that's better. That's, I think, what I was trying to get on. Yeah.
Although was involved, wait a minute, as well as the request for reconsideration, although maybe.
I mean, what I was trying to say there in that motion was that that person basically put arguments in support of that original case.
Chris Core's case.
Yeah. I believe they submitted a letter with their arguments of, you know, how they thought the case should be interpreted.
Although the party may have supported the original request instead of may be related to.
You could say that, yeah. And then I just think it's a little more accurate to what I was trying to say. And also in number 4, you have 3 ayes and there were only 2 ayes.
Okay, you're right.
And then actually also at the top, just to go back a little bit, it says members of this meeting, and it mentions Member Forsley, but I believe Member Forsley had already resigned. Because the resignation letter I saw was submitted September 27th, and this meeting was October 19th.
Okay. Anything else?
That was all I had.
Okay. So noted. I'll make those changes in the morning. Just to let the committee know, I will be away from my desk for a good part of tomorrow afternoon in case you have to reach me regarding this hearing. So just want to let you know that. Okay. So we need a motion for approval.
Hey, Cheryl, this is Member Yankee. Member Stein's name should also be capitalized, the first letter, in the vote for item number 4.
Okay.
Small, but may as well change it. She deserves to be capitalized.
Yeah. So I can make a motion to approve the minutes with the suggested changes.
Second.
Do we want to move to public comment?
Yes, please.
This is public comment on the motion to approve the minutes with the suggested amendments. Do we have speakers?
Yeah, it's possible that the public comment is going to be a little bit reduced tonight. I know we had that happen in a recent meeting, so maybe we're seeing the same thing. Anyone for public comment?
Public comment on the motion to approve the minutes.
Yeah, it doesn't sound like there's anyone, so we can probably go ahead and vote.
Member Stein?
Aye.
Member Stein, aye. Chair Schmidt?
Aye.
Chair Schmidt, aye. Member Yankee?
Aye.
Member Yankee, aye. Moved by Member Stein, seconded by Chair Schmidt to approve the minutes of October 19, 2021 with suggested amendments.
And when you're ready, Cheryl, we can move to general public comment.
Okay. This is item number 3, general public comment. Do we have interested persons in making general public comment? This is a complaint committee meeting of November 16, 2021. You are welcome to make whatever public comments you prefer.
Yes, anonymous number 3.
Do we have other public commenters?
Okay, we have one. Let's go ahead, Cheryl, whenever you're ready.
Anonymous number 3, are you ready?
I am.
Go ahead, sir.
Thank you very much. This is anonymous number 3. Good evening. I just received from the administrator one of the new notices of complaint filing. That's for a complaint I filed some time ago that uses your new pilot process for all complaints using your new respondents packet. And I had some feedback because right now the new message that you're sending has 3 different sets of instructions it references in here. The old instructions, which are the 6 set of old questions, they're still in here. And then it asks the respondent to use 2 different sets of attached instructions, quote, respondent hyphen requested information and format, and another document called preparing SOTF respondents materials. I believe, according to your motion at the last full task force, the only instructions that should be in here are the new preparing SOTF respondents materials PDF, which is correctly attached here, but there are also 2 other sets of conflicting instructions. And if you want them to use the new set of instructions and new format, you should not have in here the old instructions also, which conflict with the new instructions, and you shouldn't reference this other 3rd set of instructions, which are not attached at all. And I would urge, since this is the complaint committee, to look into that. Thank you very much.
Thank you. Members, that was very specific to our processes. So do you think we should take any action? It sounds like there's maybe a glitch in the changes there. And you too, Cheryl, if you have any sense of what to do about, I guess there's some instructions that are still being sent out that maybe shouldn't be there.
I'll look into it, Dean. I was talking to Lori about it last night, and I'll look into it.
Good. Thank you. I appreciate that. Okay. Yeah, it's let's keep an eye on that, but hopefully it'll iron out. All right. Public comment is closed. And we can move on to our next item on the agenda.
Item number 4, file number 23126. Complaint filed by Stillian Bajanski against Deborah Liu in the Office of the Treasurer and Tax Collector for allegedly violating Administrative Code Section 6724, 25, 26, 27, and 29, failing to respond to an immediate disclosure request in a timely and or complete manner, failing to keep withholdings to a minimum, failing to provide justification for withholdings, and failing to provide an index of records.
All right, so I think we will basically go through these itemized matters pretty much as we've done in the last few meetings, pretty much standard protocol. Let's go ahead and see who is here on this matter. Is Mr. Bajanski on the call? How about anyone from the Treasurer and Tax Collector's Office?
Yes, Deborah Liu appearing.
Okay, great. All right. So we may not have the complainant here.
I'm sorry, I'm here.
Oh, you are here.
I'm not sure.
Okay,
Yeah.
okay. We have everyone here. Let's go ahead and if you could give us some initial statements, let's say anywhere up to 5 minutes today, and we'll start with Mr. Bajanski. When Cheryl's ready, she needs to time you.
Sounds good.
Mr. Jason. Hello?
Yes, I'm ready.
Go ahead, sir.
Okay. Just want to give some preference. Before I get to the details of this complaint, I would like to make sure that Sunshine Task Force and the defendant have common understanding of the activities we are engaging during this call. It's my understanding and belief that Sunshine Task Force purpose is to promote more democracy and more open government than it's currently prescribed by the government code state constitution. I do believe that Sunshine Ordinance Task Force has jurisdiction and will go beyond the local ordinances in the specific case or complaint if the local ordinance violates the state laws. Sunshine Task Force disagrees with the statement made by Deborah Liu, part of the Treasurer and Collect Department, when it comes to local ordinance interaction with the state law. In an email back in September, she said the burden that you need to show is that there isn't any evidence to support your claim that the ordinance duplicates, contradicts, or enter into a few already fully occupied by state law. But if there were a conflict between local and state law, which isn't the city ordinance prevails in that charter city, which is San Francisco, has exclusive authority over their own municipal, making such city supreme and beyond the reach of the legislature enactment in that domain. If Sunshine Ordinance Task Force believes that the city ordinance prevails in the charter city and have exclusive authority and right to violate the state's laws, I would like to end my statement here. That will prove that the local ordinance, together with the Sunshine Task Force, promote authoritarianism, and the purpose of this course is to further humiliate the petitioners. And that being said, I would have submitted public response number 214840 on September 9, 2021. I have attached the image. I received a response on September 20th, 2021, to my understanding by Francisco Chavez, saying due to the mayor's order, the agency are not required to provide information within 10 or 14 days. And then he moved the request response date to October 15, 2021. With this statement, Francisco violated number 1, Government Code Section 6253C, specifically the following: notice shall specify a date that will result in an extension for more than 14 days. And Section 6253.3, except otherwise prohibited by the law, state or local agency may adopt requirements for itself that allow for faster and more efficient or greater access than prescribed by minimum standards set for this chapter. And I have attached the image here, and this is the end of my comments. Thank you.
All right, thank you. And now we can hear from the respondent when Cheryl has her timer ready.
Ms. Lou, are you ready?
Yes, I'm ready. Thanks. Good afternoon or good evening. We are being accused of violating various duties that are afforded under the Sunshine Ordinance. But what I think that the petitioner is missing is that the mayor has suspended aspects of the time and what we have to do, as opposed to responding to the public record request that was made to us, which we timely did. We stated everything that we were supposed to state. We said that it was under the mayor's order that we don't have to produce documents within 10 calendar days or within the 14-day extension period, which is what you can do under certain circumstances. But instead, we fell back on the government code, where we state that we have located documents that would be responsive to the request. We also respond by saying some documents will be withheld because of the attorney-client privilege and work product privilege. And then we gave an extension, not an extension, but an estimated date of production of the records. And what I think we will go into when we go deeper into my case is our section had undue hardships, but was working with due diligence, and we did produce the records as promptly as we could. And we actually produced documents 10 days before the estimated date that we thought we would produce documents by, of October 15th. We actually produced documents by October 5th. However, the complaint was filed before we even had a chance to complete our review. Thank you.
All right, thank you. And at this time, we may have questions from the members to the parties. I open it up. Members.
This is Member Stein. I have a couple questions for Mr. Bajanski. Did you ultimately get the documents you requested?
I don't remember, but this is not the issue of this request. It's the issue of timing.
Okay, so you don't remember. Do you have any reason to believe that some documents were withheld from you?
Yeah, some documents probably were withheld. I don't remember, but right now we are talking about the timing of the request. I received it with huge delay. That's the reason for my complaint.
I'm asking this question because you're alleging violations which include violations saying that some documents were withheld and were withheld without justification. So I'm trying to understand if that is part of this case. Are you saying it's not? You don't intend to allege that? It
might be part of this case. There were like few cases that were part of the many requests I had to the department, so I'm not quite sure whether this one in particular I received. Probably I received some documents, but with huge delay. So what's the reason for the delay? That's why my call is about.
Is that the only allegation you're concerned with in this case, is whether they were provided in a timely manner?
It's part of the law. It's law says the
yeah, I understand.
Law says no more than 14 days. They provided it on the 15th day. So it's a violation of the state law. So if that's not enough, okay, that's fine. Let's hang up this call and stop here.
Hey, Mr. Bajanski, I just want to explain to you that when I read the case, there's 4 different allegations that are being made, and I'm trying to understand.
Okay, so we can drop all the other allegations because I'm not quite sure whether they are. Let's focus on only this, that it concerns time.
Okay, so you are only concerned with it not being provided in a timely manner.
Right, correct. That's right.
Okay, and can I ask, is there pending litigation here? And this is a question for the petitioner or the respondent. Is there any lawsuit or pending litigation here?
Yes, there is.
How is
Okay.
that related? I'm not
It's
clear.
only related because there are exemptions that allow agencies to, go through documents to make sure if there is some kind of
Well,
pending
can you provide
litigation.
such proof with the state law? Can you provide such proof with state law? Because state law it says no more than 14 days, and you did it 15 days.
Yeah, I went back and I read the state law, and maybe the other members can speak to this, but to me,
Sure,
it looks
let me
like
refer me. I'm ready to search a specific thing that you in the state law that gives you more priority. It clearly says, to me, it clearly says 14 days.
Yeah, to me, I guess I wonder what the other members think of this, but when I look at the state law, it says that there has to be a response within 14 days about whether they have the records, but it doesn't say that the records are provided automatically in 14 days. Can anyone
But
give
they provide
clarification
it a
on?
lot more than 14 days. They provide, I think, 25 days, or I don't know. Like, I don't have the exact numbers, but it's more than 14 days. They say on the 10th day, they say, I think they said we need more time because mayor give us the right to have unlimited time or something like that. So, but still, they send me then the 15 days on the top of 10 days, and by state law it says up to 14 days, and that's the problem basically.
Okay,
Member
that's
Stein, I think your reading of the timeliness issues is correct. I wouldn't add anything to that.
okay. That's all my questions for the petitioner and respondent.
Thank you.
Okay, I have
For the respondent,
a couple questions. I'm going to ask a couple questions of Ms. Liu. One is, could you describe what the pending litigation is that was just mentioned?
yes, the Office of the Treasurer and Tax Collector represents the Office of the Short-Term Rental section of the Planning Department for violations. And
Okay.
those fines have not been paid after the final determination.
All right. Is it in a Superior Court litigation status, or is it preliminary to that?
No, it's been filed. We have a lawsuit pending. It's been
Okay.
filed, it's been served, and there has been an answer filed. And what he's doing now has, anyway.
Okay.
It
Thank
really
you.
has there's no reason for him to be asking for the emails, but we did give them. We gave him over 200 documents. And let me tell you about what the hardship is, if I may.
This is irrelevant.
Mr. Bajanski, I need to just hear from Ms. Liu.
Sure.
Let's take turns here. Thank you. Go ahead, Ms. Liu.
Okay, so we have had a very limited staff during the time period for which we received, from the time we got this PRA to the time we responded. We had our first legal assistant of 3. The first one went on leave in June, and she still hasn't returned. We have a second legal assistant that went to law school in July, and we didn't get a replacement until October 18th, which is after the date we had already produced the document. Then our third legal assistant went on medical leave, coincidentally, on September 9th, the day that we received the PRA, and he was scheduled to return on the 4th. He did come back on the 4th, but it was less than a full day. And once he did come back the next day, which was a full day, I immediately enlisted him to assist Francisco Chavez. And he completed what they needed to do. And I want to note that Francisco Chavez is just incredible. He is actually our legal secretary, and he's acting as a legal assistant, but he has primarily legal secretary duties as well as some legal assistant duties. So, he and I were the only staff that was around from September 9th through October 5th. He opened and or closed 24 other Public Record Requests Act, Public Record Act requests, and some of them were complicated. He conducted some other research on other projects. He worked on tracking. He does his secretarial duties. He sets up hearings. And I'm sure he was overworked, as was I. So as soon as we were able, we made those records promptly available. We are following the government code, which says, you know, you make the representation, and we did that on the 10th, what I'm going to call the 10th day. It was actually a Monday, since the 10th day fell on a Sunday. We were timely. We got documents on the 15th day, which was, to me, pretty incredible, because I had estimated that we would need more time, being that there were only two of us. And
Thank you, Ms. Liu. And I actually
responded.
I actually am impressed with the presentation you're making about how this was processed. I just want to confirm, it sounds like you're saying that all required documents were produced, all required non-exempt documents were produced, and they were produced within the legal time framework. Is that your position in this matter?
Yes, it is.
Okay, that's what I wanted to inquire about. I have no other inquiries of you at this time. Thank you. Members, any other questions? Yes, I'm going to just go to Member Yankee and then Member Stein.
Okay, this is for the respondent. I just want to make sure I have the timeline correct here. So the initial request to you was made on September 9th, correct?
Correct.
And you responded with your initial response as required under 6253C on September 20th, which was a Monday, correct?
That is correct.
And in that response that you sent on September 20th, what date did you inform the petitioner that you would have the records requested, the requested records available by?
October 15th.
October 15th. Okay. Then this is my question to that is under 6253C, it says no notice shall specify a date that would result in an extension for more than 14 days. So if September 20th, 14 days beyond September 20th would be October 4th.
Right.
I guess I'm confused about how telling them that October 15th would be the deadline complies with 6253C.
Because, and this is the same misunderstanding that I think Mr. Bajanski has, which is the law is you must respond with your initial response within 10 days, but you can get a 14-day extension under certain circumstances for that initial response. The response does not mean that you have to produce the documents within 10 days with a 14-day extension under state law. So that's where the mix-up is. So what you do, and what the memos from the city attorneys wrote to London, Honorable London and Greed, and members of the Board of Supervisors, I think, on March 30th, was that they must respond within the time period and then give an estimated date when the agency will make the records available.
Okay, I understand your response. Thank you. That's all I had.
Okay, thank you.
Thank you.
And now Member Stein, I believe, has.
I realized I had one more question for the petitioner. I realize there's a discrepancy between the petitioner saying this is an IDR request and the respondent saying this was not identified as a immediate disclosure request. And nobody in any of the documentation submitted any copy of the original request. And my question for the petitioner is, do you have a copy of the original request which shows that it's an immediate disclosure request that you could submit to us?
Here I'm just talking about even regular request. Immediate what's the purpose of looking at the immediate request? They responded with like what, 25 days after the request, which is still a violation of the state law to me.
Okay, so, and again, I'm just trying to understand if we send it forward to the task force, I would like to send it with the correct alleged violations. And if this is not an IDR, I'd like to take those out and just have
okay,
it.
then take it out. Okay, sure, take it out.
Okay. Well, I wondered if, because you say it's an IDR, do you have a copy of the request?
Oh, I probably need somewhere. I for sure have it since I submitted it. So it should be somewhere in the document.
Wasn't submitted.
I can dig it up. I mean, right now I cannot send it immediately.
I'm just saying when this goes forward to the task force, if you want to have it looked at as an IDR, I think you should have a copy of that request there.
But the problem is when you make a request on the web page, you just click submit and everything just disappears and you don't know whether you made the request, whether you not. You just wait for Cheryl to kind of reply back saying, maybe I got your request.
It doesn't send a copy or anything?
No, it doesn't say. I mean, I'm not sure. It doesn't even say it's a successful submission. It's just blank page.
It's not a good system.
If I may respond, if you can look at page 25 of the agenda, that looks like a copy of what I'm looking at. Mine only has letterhead. But there is page 25.
P25 of the complaint file? Is that what you're saying? Okay.
I call it an agenda, but yeah, of your.
Okay.
And then it'll say on the bottom, request 214840, and there's no language there that it is an immediate disclosure request.
Okay, so then don't treat it as immediate disclosure request. I mean.
Okay, yeah, I see that. Okay.
The only argument we have here is about timing. I mean, also a violation. I put two things. I mean, either one you can take.
Well, just so you understand, Mr. Bajanski, the timing is different for an immediate disclosure request versus a regular request, and that's why I'm
asking. I do understand, but even if you treat it, I mean, what would happen if this was immediate request, even worse than that? So I don't understand if it's there or not, what makes a difference in this specific case.
All right.
Anything further, Member Stein?
No, that's it from me.
Okay. I think we could then talk about what we want to do with this, and if somebody has a motion, we can figure out how we're going to vote on that. Any thoughts?
This is Member Yankee. I think the argument here for the full task force to consider is whether or not 6253C was properly followed or not. I think Member Stein's questions, which I think were fantastic, that the parts about whether or not the records were completely turned over and all that, I think that's no longer an issue. I think we're just looking at timeliness. I think we also, kind of settled the immediate disclosure part. So I think it's really at this point, the only thing the task force has to look at in regards to this case is 6253C.
Agreed.
I would also agree. Yeah, since 6721B was sort of suspended by the mayor's orders. So I would support a motion to move it forward to the full task force.
How come?
Mr. Bajanski, sorry. This is a period where we talk amongst ourselves.
All right, I mute myself.
We've already.
Sure.
Yeah, thank you.
Okay, thank you.
We're making a decision now what to do next.
So I would support moving it forward to the full task force because it's, in our jurisdiction, it's public records, but with the only question being whether 6253C was properly followed. And unless you already made that, I'll second it.
No. I might make it. I'll second yours.
Okay. All right. I would take out these other 67.24 and to 67.27 and 67. Let's just get rid of that because that's going to waste everyone's time when the real question is 6253C.
Yeah, I think the agenda needs to be clear when Cheryl does it, that it only lists 6253C.
Mhm.
Just that Mr. Bachiansky seems to also have indicated he's only interested in the timeliness issue. So it's also per complainant. Yeah, motions made and seconded. And so let's, when you're ready, Cheryl, let's take that motion and open it to public comment.
May I read something?
Not at this time.
Do we have public commenters on the motion?
Anonymous number 3.
Do we have other public
Okay.
commenters?
We have one.
Do we have other public?
Oh, go ahead. Sorry, Cheryl.
All right. I'm just putting out the call for public comment. We have one public commenter. Do we have others? Okay, it looks like we have the one.
Someone else is talking.
Yeah, let's figure out what the distortion is before we hear from anonymous number 3. Looks like it may be gone now. So whenever you're ready, Cheryl.
If you're not speaking during public comment, we ask that you mute your telephone by pressing *6. Okay. All right. Anonymous, are you ready?
Yes.
Go ahead.
Thank you very much. This is anonymous number 3. I'll say something that I've probably, maybe I've said only once before. I partly agree with the city in this case that 6253C, even after 24 days, that law specifically only requires the notice of disclosable public records and the reasons thereof, and the justification. Nothing else is required solely for 6253C. And that's within 10 days. You can even either give that notice right then, or you can give an extension within 10 days so that within 24 days total, you give the final notice. The issue of whether, and the task force has considered this in the past regarding cases during the COVID emergency period, is whether you believe the 25 days was a prompt production of these records given the circumstances. I don't know how many records were produced. Is it hundreds of records? Is it 2 pages? And that you shouldn't, the full task force shouldn't forget to look at that, which is 6253B, which is whether or not the records were made promptly available to the requester. And that's a subjective thing, right? You have to look at how many records there were and how long was the total amount of time taken, even if they did meet their obligation under 6253C to provide the notice within 10 days. Second, I don't understand what happened with that pending litigation thing, but it is the case that simply because you have pending litigation doesn't mean records about you are exempt under the pending litigation case, and there are citations. I can put those into public correspondence. In order to qualify under the pending litigation exemption, the records must have been prepared for use in the litigation, and not just older records that they now find out they're being sued about. I'm not sure if that's happened in this case, but unless this committee is certain that the 6727 and other 6724 regarding those issues aren't correct, I think the process is normally that you recommend the full task force only look at this, but you don't actually change the complaint, unless maybe it appears the complainant is, I guess, conceding all those other points. But there may be something to the pending litigation exemption, whether or not it's being used properly in this case. That's all. Thank you very much.
Thank you. All right. After public comment, public comment on this matter is concluded, and so members, are we ready for a vote? I think we can go ahead when you're ready, Cheryl. And do you, Cheryl, do you feel like you've got the substance of the motion so it can be clear?
I thought it was pretty simple to find a violation of 6253C and to remove the other violations from the summary.
Okay, so to just to clarify for all the parties, we can't make a final decision. We're simply looking at this matter and sending it forward to the full task force where the decision would be made. And so we're just looking at this matter, and you'll see what our conclusion was for purposes of what this committee does. All right, it sounds like you got it, Cheryl. I think we can. Yeah, Member Yankee.
Yeah, Cheryl, you said fine violation. I think we need to be clear that we're not finding, like Chair Schmidt just said, we're not finding violations that should not be in the motion. We're recommending that the task force consider a violation of that. We're certainly not finding any violations.
Absolutely, thank you.
All right, you ready for a vote?
Oh. I just had a point of clarification, or I want from my fellow members here. So what is the best way to try to get something off the table if it's being claimed that it's an IDR and then there really is no evidence that it's an IDR, in fact it's not an IDR? What is the best way to streamline it so that when it goes to the task force you don't repeat this conversation, or do you have to repeat this conversation? Or, because I thought that part of our job here was to try to get things a little bit straightened out before they go to the task force. So I'm just wondering if you have any thoughts on that.
Well, in this case, I would say we can take advantage of the fact that the complainant has acknowledged that it wasn't an IDR, and that the one issue he wants decided is timeliness. And so he's not making any other claims. So, we could clarify that he's dropped other contentions. I'm not sure if we could really, the way these rules are written, which I still don't quite understand why they're written this way, but they say we can't make any, we can't dismiss anything or change anything other than that.
This is Member Yankee. Yeah, I think we did about the most we can do with calling the part of the government code that we want to this task force to focus on. I think that's probably the extent we could do. And then obviously when Chair Schmidt gives his report, he can summarize this case and discuss how we kind of hashed it out and that the petitioner wanted us to focus really on timeliness.
Okay, thanks.
Okay.
Ready for a vote?
Yes, let's vote.
Member Stein?
Aye.
Member Stein, aye. Member Yankee?
Aye.
Member Yankee, aye. Chair Schmidt?
Aye.
Chair Schmidt, aye. Moved by Member Stein, seconded by Member Yankee, to find that there is jurisdiction, that the records are public, and that the task force, and refer it to the task force, and that they consider a violation of 6253C, and that the removal of punitive sections 6724, 25, 26, 27, and 29 be removed from the complaint. Is that correct?
Yes.
Are we ready for the next item?
Yes, please, Ms. Lejay.
Item number 5, file number 21136, complaint filed by Anonymous against Catherine Porter, Elizabeth Colbrith, and the Office of the City Attorney for allegedly violating Administrative Code Section 6721A and B and 6725B by failing to respond to a request for public records in a timely and or complete manner.
All right, so there's an anonymous party here. Are you present for this hearing? Okay, I'm not sure if we have the complainant here. And who do we have from the city attorney's office? Is anybody here for this matter? 21136.
Hello, good evening. Can you hear me?
Yes, now we can.
Hi. Jen Court here on behalf of the city attorney's office.
Okay, great. Thank you. Okay, so I'm not sure if we are going to hear from the complainant here. If the members are okay with this, we could just ask the city attorney to make a statement, and then we can, if we have any questions for the city attorney, and then we could move to figure out if we want to move this forward or whatever we want to do. Okay. Yes.
I think in a situation like this where the petitioner is not available to make comment, that we table the matter and let the petitioner know it's been tabled and notify them that they have 60 days in which they can reopen their complaint. And if I'm incorrect, Administrator Young, am I correct on this?
Yes, that is our standard.
Yeah.
But
that's fine with me. If the members are fine with that, in this case, it seems like a good way to go. I'm not sure if just looking at the documents, if they're not here, it may be that they don't want to pursue this. I don't know. Members, any interest in going ahead with this?
This is Member Yankee. I think for consistency's sake, we should invoke the rule that Cheryl and Victor spoke to, which is part of our complaint procedures. And then, of course, if the complainant wants to reopen, they certainly have that opportunity within 60 days, and we can put it back on the agenda.
Okay, let's do that.
Sometimes things come up and they can't be.
Yep.
Yeah.
So,
go ahead. Sorry.
Oh, so I'm sorry. So I was going to say I'll go ahead and move then that we table this file pursuant to complaint procedure 7B for non-attendance of the complainant.
Okay, so we have a motion.
I can second it. This is Member Stein.
Okay, so we now could see if there's anyone who has public comment on this matter.
Anonymous number 3.
Anonymous number 3, are you ready to speak?
I am.
Go ahead, sir.
Thank you very much. This is Anonymous number 3. I just wanted to point out I was accidentally noticed by the SOTF for this complaint, which is not my complaint. And I informed something's happening. I informed Ms. Leger that I was the one given notice of this meeting. So I do hope that the actual Anonymous, whoever filed this complaint, was noticed in a timely fashion for this meeting. That's all I wanted you guys to know. Thank you.
Aha.
Yes.
Okay,
we can double check notices we sent out, and if it is our error, we will go ahead and reschedule it. We'll double check the email to be sure we did send out the correct email.
Okay.
And if we did make a mistake, we will automatically just reschedule for the next available meeting.
maybe we should alter our motion somewhat then, so that the process doesn't let this thing fall through the cracks, and say that.
We can just put it to the side for now. We can double check right now. If you give me a few minutes.
Oh, yeah, that's
I'll double
great.
check the notice of hearings right now, and I'll get back to you if you give me a few minutes.
Okay, thank you, Mr. Young. And I will, let's say that we're going to see what's happening with that. Go ahead, Victor. I guess we'll just hold on. Thank you to the city attorney's office for just being ready to go on this. Sometimes these happen.
No worries, absolutely.
No, I think the error was mine because I did send her an email.
Saying what?
That we received her complaint and that I needed her initial request and responsive records, etc. So that's the only, looks like I remember getting Anonymous's email and I remember acting on it, but I don't see evidence of it.
So the notice of this hearing was not sent to the person.
Yep.
Okay, it was accidentally sent to our Anonymous 3. Is that what you're seeing, Cheryl?
Yeah. Yep.
Okay, so we can't we gotta reset this then, and give them an opportunity. Okay, thank you. Maybe we should let's see. I'm not sure exactly how to handle it administratively, but we can't resolve this because there's been no notice to the complaining party. And so I guess we want to put it back into the shuffle to come up for the next hearing. Why don't we see if we can set it for the next hearing of this committee?
Yes, we can continue it to the next meeting of the complaint committee.
All right, let's do that.
And we'll make sure we update any notices we need to update.
Excellent.
We should probably make a formal motion on that just because this is an action item on our agenda. So I'll move to continue this item to the next complaint committee hearing.
Great. I'll second that.
Okay.
Yes, we just having trouble keeping the anonymouses separated. We have so many of them, and they do get confusing.
Yeah, that's I guess that's the downside of anonymity is.
Who wants the second?
Okay. I seconded Cheryl. Yeah, so I guess we have a new motion, so we should go ahead and see if there's public comment on the second motion, the different motion. So is there anyone here for public comment on this?
Anonymous number 3.
Okay, thank you. And I do want to also thank you, Anonymous 3, for telling us something that was relevant to that case. I know it's not one of your cases, but we appreciate the help on that. But when Cheryl's ready, we could go ahead with public comment.
Are you ready, sir?
Yep.
Go ahead.
Thank you very much. It's Anonymous number 3. Just responding to 2 comments just made regarding this. We are instructed not to use pseudonyms. It's in your rules. All of us anonymouses have to call ourselves anonymous. And that was some argument between the task force and the city attorney's office and some other anonymous long time ago. But that's one of your rules that you you actually don't allow us to use pseudonyms to identify ourselves. But we are we are given the opportunity to give a contact information. And so, for example, this person's contact information is not my contact information. Thank you.
Thank you. Okay, let's vote on this.
Member Yankee?
Aye.
Member Yankee, aye. Chair Schmidt?
Aye.
Chair Schmidt, aye. Member Stein?
Aye.
Member Stein, aye. Moved by Member Yankee, seconded by Chair Schmidt to continue this matter to the next complaint committee meeting. You ready for the next item?
Yes.
Item number 6, file number 21141, complaint filed by Claudia Ovalis against the Office of the City Attorney for allegedly violating Administrative Code Section 6721 by failing to respond to a request for public records in a timely and or complete manner.
And we do also have a discrepancy here because I believe Ms. Leger, you just read against the city attorney's office, but I noticed in the file that it had been sent out to the city attorney's office, but I think the complaint is actually against the district attorney. And so you then sent a revised but undated notice to the DA. And so let's just make it clear, as far as I understand, this involves the district attorney, not the city attorney. And I was going to ask you, Cheryl, what was the date that you sent this to the DA's office? It was on our record, page 175. And while you look for that, I'll ask you, is there anyone here from the district attorney's office? I don't hear anyone yet. Is there some chance that someone appeared here for the city attorney's office? Okay, which
yes, Jen Court. I'm sorry, Jen Court is still here from the previous item, but as far as our understanding is, this is a complaint against the district attorney's office.
Okay, thank you. And I believe that the notice to your office was sent incorrectly. I don't know why, but I think we'll probably get this disposed of real quickly. And let me just clarify. Yeah, and it doesn't sound like anyone's here for the DA's office. So I think we do need to figure out if they were notified. Is there anyone here? Is it Claudia Ovalis? Is Ms. Ovalis here for this hearing? Okay. No, other than the city attorney's office, who we know is here for the last hearing, are there any of the parties here for file number 21141, last call? Okay, well, they're not here, so we probably should consider what Member Yankee's motion was on the last matter and do that so we go into the 60-day process, because the complainant is not present. And so if the complainant's not present, I'm not sure if it even matters what the notice to the DA's office was for purposes of what we're doing today, if we want to have that be the motion.
This is Member Yankee. I totally agree with you, Chair Schmidt. We just need to make sure that if the petitioner does want to reopen this, that Cheryl, that you have the proper person, at the district attorney's office to notice rather than the city attorney, in case that were to come to pass. I think right now with the complainant not here, I think we're kind of bound by the complaint procedure to.
Hello, I'm sorry.
Oh, we have someone here.
Yes, this is Claudia Ovias. I'm sorry, I was having technical difficulties.
Okay, thank you. So now we know you're here, and so we can skip what I was just recommending because we have a complainant, but the district attorney is not here, but we don't know what type of notice they got yet. And so then I'll put that request back to you, Cheryl. I know that notice was sent to the city attorney's office mistakenly, and then there was a revision, but I don't know if that was done with the required time for notice.
I'm sorry, I believe it was sent on November 3rd. It was a resent. It was resended, the notice to respondent, due to typographical error. Oh,
so Ms. Ovalis, you have a record that there was a resend on November 3rd to the district attorney?
Correct.
Okay. Cheryl, does that sound right?
Yeah, it does, because they notified me, the city attorney notified me of the incorrect noticing of them.
Yeah.
And I remember scrambling to that.
Okay. So November 3rd, so that's 13 days. So it looks to me like the district attorney was notified of this hearing, and they're not present.
Just briefly, this is Member Yankee. I'm looking at the resend, and it's page P177 of the file. But what's odd about it is that the date line is missing. There's no date and timestamp on this email. So, Cheryl, can you confirm that this was actually sent and not something that just kind of maybe was sitting in your outbox that never got sent? Because the email, the original email, which was the one with the typographical error, that does include a date and timestamp, and that's on P178, and that shows, sent Tuesday, November 2nd, 2021, 3:09 p.m. But I don't see a sent line on the one on P177. So I want to make sure that this actually did get sent and wasn't just like a draft that was sitting in your outbox.
Not in my outbox.
Can you look to see that in fact it did actually get sent?
That's what I'm looking at right now to figure that out.
We do have an indication, which I think is relevant and important, that the complainant said that the complainant became aware that notice was sent to the DA's office November 3rd, the revised notice. So it does look like there is something there to confirm that it was done at that time.
Yes, sir, because a few individuals were included in the email, and then the complaint was attached.
Yeah. So my thinking is, if they did get that revised notice, we probably would want to consider going ahead and having this hearing and seeing if we have something to send to the task force. But let's see if well, I'm not sure if Cheryl can confirm, but even if she can't confirm, I mean, we do have that notice, and we do have a witness who says that they saw that notice come through 13 days before this hearing. Cheryl, anything that you can add?
No, I'm just going to say that sounds right, because I did hear from the city attorney, and I do remember making a correction.
Okay. So members, it would be my inclination to go ahead and have this heard and hear from the complainant and go ahead with our process. Do you, in the circumstances, do you feel that we should do something differently?
This is Member Yankee. I'm still not understanding why the date line is missing on this particular email when it's included in every other email that Cheryl's included in this packet. This is only, not 2 weeks ago. So Cheryl, I mean, I really would like you to confirm one way or the other if you can look at your sent mail and say, yes, this did go out, this was the date and time it was sent, or no, it did not go out. But I think, I mean, not that I'm discounting the petitioner by any means and saying that she's not being truthful or anything, but we've all now seen the email in the packet, right? We know that there is some type of email. I want to make sure that it actually was sent at the date and time that it was alleged, and Cheryl should be able to do that by taking a few minutes now and looking in her sent mail, and she should be able to read into the record exactly the date and timestamp from that. And if she can read that, then I'm fine with continuing.
Let's go with what Member Yankees requested. Yes.
Yeah, that's no problem. I just want to be sure. She said that I sent this on the 3rd. At what time? There's no date and time.
Well, right, Cheryl, that's the problem where we want you to, I mean, it should be, if you originally sent the original one on the 2nd, it should be shortly thereafter. So if you could just pull up your Outlook mailbox and look in your sent mail folder, see what you sent on the 2nd, 3rd, and 4th, maybe that would be the next, few days from that mailbox, and see if you can find it, or sort your mail by the, the sender.
May I provide the time?
Yeah, that would be helpful since you'll know where to look.
I received it at 12:09 p.m. on the 3rd.
Thank you. Thank you.
Now, I'm on Central Standard Time, so I'm not sure if that would be different from your email.
And it was sent directly to you and
you copied the district attorney's office. I was CC'd, but you sent it directly to the district attorney's office and there was 3 individuals that it was sent to. And the attachment, the complaint procedure at the header of the 2nd page actually lists the date and time of just has I guess the public complaint procedure isn't included.
Cheryl, this is Victor. I would suggest checking your own email box. I did check the SOTF email box and I did not see it there. So maybe check your personal email box.
that I'm looking at right now.
Mm-hmm. I did see the letter from the city attorney to the SOTF informing us of the error, but I did not see anything going out from the SOTF box on 11.3 regarding this file.
I'm not seeing it.
Yeah, the email, it came from SOTF at sfgov.org. And then the subject was SOTF complaint filed with the Sunshine Ordinance Task Force, file number 21141.
This is Member Yankee. That's not. Wait, I'm sorry. No, maybe it is. Yeah, 211. I'm sorry. I take that back. No.
And then there was another email sent on the 12th with the agenda packet. And that was included in that was the district attorney. And that was at 1:24 p.m. on November 12th.
Thank you.
The agenda packet was sent out November 12 at 11:25 a.m. and included Ms. Ovales, Chesa Boudin, and Robin Burke. Chesa Boudin and Robin Burke being of the district attorney's office.
Okay.
The agenda packet is the complaint committee.
And Cheryl, in response to Member Yankee's question about the earlier item, it sounds like it's not findable. Is that fair to say? If it's not findable, it's not findable. Or if you can't be found, you don't know if you. Are you still looking? In other words.
Yeah, I am. But if you want to proceed with the hearing.
Well, I don't want to cut off Member Yankee's request. So if you still need to keep looking for it, that's fine. That's fine.
Yeah, this is member. My concern though would be that if we were to proceed with the hearing without confirmation of that, and then we get to the full task force, and the DA says that, hey, we never got notice of this, I don't want that to muddy up
But
a full
it's,
task force
I mean,
agenda.
if they get, Robin Burke is, first of all, she's very responsive. She does appear at all our hearings. So I'm kind of surprised she's not here.
I think the question is, we just need to confirm that we actually sent them notice of hearing, and we need something. We need additional. We just need to get a copy of our out mailbox, confirming that we actually sent the notice of hearing out. Otherwise, if they don't know about it, they can't respond. So we just need to be sure we sent it out. So
just to clarify, right
Good,
now, we're asking Cheryl to try to locate the November 3rd email that would have gone to the district attorney's office. That's the one thing that's not been located, but that doesn't mean that, we're just trying to find out, can it be found or not be found?
May I send it back to SOTF right now? Forward it back?
That's it. I remember Yankee. What do you think of that?
Well, let's try it and see what it looks like.
Okay, so I send it back to SOTF.
I will take a look for it.
SF.gov. That says?
SOTF
Okay,
at sfgov.org.
Yes, I'm sending it now.
Okay, I will go look for it. Okay, I did receive it. I'm opening it up now. Let me take a look. This version does have a date. It is dated and timestamped. Give me a moment.
Wednesday, November 3rd, 12:09 p.m.
Just give me a quick moment.
Did you? You're Cheryl. You're looking at the one that was just sent, right? The copy that was just sent by Ms. Avalis.
Mm-hmm.
Okay.
Give me a quick moment. Oops. I'm just trying to. I'm going back and forth between two computers, and it's just causing me issues.
That's not the notice of the hearing. That's a notice of a complaint.
Give me sorry, my apologies. I'm just trying to figure it out. And
That's a good point, Cheryl. This is member Yankee. The email on page 177, now I look at it more closely, is actually the initial notice of a complaint that was filed. It's not the notice of the hearing. It's
Right.
not a sending of what was on page 178.
What I sent was a re-notice to the district attorney's office saying that they had been noticed on this complaint and that I shouldn't have sent it to the city attorney. It should go to the district attorney. And I have that email.
Okay.
Okay, so it does sound like what was sent out to the DA was not what had been sent to the city attorney the day before, which was the notice of a committee hearing. All right.
I just forwarded the complaint committee 11/16/2021 meeting agenda and packet online, and that includes the district attorney. That was November 12th at 1:24 p.m.
Yeah, the 12th.
So, Chair Smith, just to summarize, I believe that they did get a copy of the agenda packet, but they did not receive a specific notice to appear. My suggestion for now is you can listen and take information at this time, and after that, you may wish to either continue this if you think we need to come back and allow the
Respondent
attorney to make their own presentation. But I don't see a problem with gathering initial information at this stage. And just as long as we continue it and allow the other party to present at a future hearing.
I'm open on this myself. I don't think that the notice, I don't think that the DA knew about this hearing until last week. But for purposes of what we're doing here today, we could hear from the complainant. I mean, I hate to have the complainant show up here today and we're telling them, oh, well, sorry, we didn't send the notice to the other side. That's just not, it's just not, I guess that's kind of frustrating. But members, what would you like to do? Any thoughts?
This is Member Yankee. I mean, we could hear from the petitioner today, but I would not feel comfortable making a motion on this because I don't believe that the respondent was properly noticed. I think we've kind of confirmed that around. And so, unfortunately, I'm not sure that there's a way around having to have this on a future agenda again. It's just how much we want to hash out on this particular agenda, but I don't think we can close it out and send it on at the end, at the conclusion of this meeting because of the administrative error. So I guess I would put it up to the petitioner if she wants to speak, but know that even if she wants to speak and present today, that it's still going to have to go to a future complaint committee meeting as well, so that the respondent has the appropriate chance to respond as well. So I don't want to have her go through two presentations if she doesn't want to do that.
Why don't we do that? Let's let the complainant speak, and yet with the knowledge that we're going to need to continue this. It does look like, from the file at least, the DA's office, this thing is set for 6 months and nothing's come from the DA's office to the complainant. So let's just, let's confirm that that's what's happening here in the complainant's presentation. Okay, so at this time, when Cheryl's ready, if the complainant would like to make a presentation, let's go ahead and hear from Ms. Ovalis.
Okay. I'm sorry. Yes, I filed this complaint because I initially submitted a public records request. I've done two. I did one March 15th through an actual employee at the district attorney's office, and then I filed initially through email through the district attorney's office. And at neither time did I receive any type of 10-day notice that we're working on it or any type of acknowledgement I have continuously tried to do a follow-up on the public records request, but I have not received any type of response. I've even called and left a message with their voicemail and through the victim services line, and neither department or division has returned my call. I just know that when you submit a public records request under the Freedom of Information Act, there is some sort of acknowledgement response within 10 days, and if they need more time, they would respond and explain the reason for that extended time, and then eventually follow up to close that public records request status. But I have not received anything in response.
Thank you. This is Chair Schmidt again. I think that we're going to be forced to move this. I want to have it move forward because when we look at this again, we're probably just going to move it on to the full task force, although I can't speak for what we'll do, but I want to have it heard next month. And so I'm going to make a motion that we continue this to the next available complaint committee hearing, and we will get the proper notice out to the DA's office, and then they will have an opportunity to, either tell us that they have done something or just try to give us an explanation why they haven't done anything to respond to Ms. Avalos. So I'm going to just make the simple motion that we move this, continue it to the next complaint committee hearing.
Can I just ask, because, or is this not a good time to ask?
Oh yeah. Sorry, I didn't mean
right.
to skip on. Yeah, go ahead.
Can I just ask, because this is kind of an optional process that we've put in, right? To have these cases kind of pre-screened in our various committees. And can I just ask, is there a reason why we wouldn't maybe consider sending it to the full task force anyway, given that, there's nothing, there doesn't seem to have been any response from these respondents. I have in my notes, I was already, going to, based on what I have seen, move to have a hearing for, violation of certain sections of 67.21. Maybe just for the sake of expediting, we can send it to the full task force, having noticed the DA, and the DA can just present their response there.
I withdraw my motion. I would, to me, the way these rules are written, I don't see why we have to just, with a case like this, why we have to mess around with it and not send it to the full task force. I can't imagine what the DA could say that would cause us to make any decision that's different. So yeah, these rules are the rules we're supposed to follow, but I don't know if they forbid us from just moving this case forward. I do see that Member Yankee has his hand up. So Member Yankee.
Yeah, I agree that we could do that. I don't think that there's something that prohibits us from doing that. My concern would be that if they weren't noticed initially, not only are they not here to make a presentation, which is one thing, they weren't even noticed to supply any written documentation on their behalf, which means that we don't even have any documentation to look at. They may have a lot, maybe nothing. We really don't know. So the danger of sending it on without any written or oral response from the DA is that now this goes between, in front of the full task force in one of their already very lengthy meetings, and then we're trying to rehash this from the very beginning because they haven't had an opportunity to do any of that. I would feel more comfortable if they may have just missed the chance to make an oral presentation, but we at least had some type of packet from them. But by them missing the notification, they weren't even told to submit any written documentation. So we have 0 from the DA's office. Now, it may be very cut and dry, or they may have an extremely compelling reason why they didn't turn it over. We just don't know because we have nothing from them.
Member
So yes,
Yankee,
yeah.
they did receive notice of the complaint. So
Is
they
that
should
when
they should have responded within 5 days of receiving notice of the complaint.
do they typically respond with the?
People they typically respond when they can, you know, and in most instances, departments respond as timely as they possibly can. I mean, they got notice of it, so.
Right. But it's the note. I mean, I'm looking at the email that you sent out. It's on P178 and P179. This is obviously the one that they did not receive. But it says for a document to be considered, it must be received at least 5 working days before the hearing. See attached public complaint procedure. But they never received that. So they never received the, hey, if you want it included in the packet, you have to get it me within the next 5 days email. That's the problem.
Okay.
So, I mean, yeah, they did get a notice of the complaint, but they may not have known that, hey, now's the deadline for they may have a whole packet waiting to send to you, but they just didn't do it yet because they didn't get the notice.
But they can also send it to us and have the whole task force look at it.
They could, but we run the risk of this being longer at the full task force hearing.
So are you asking?
Essentially combining the committee stage and the hearing at the full task force. We can do that. I think. I don't think there's anything that prohibits us
to avoid things like that. And I'm asking if you guys, if the complaint committee would prefer to continue this matter to the next complaint committee hearing.
I mean, Victor, in terms of hearings before the full task force, we're already booked out through March. So having them come back in a month won't delay a full task force hearing. And I can work with the chair of the full task force to move it up on the calendar if needed. But in terms of the full task force, we're already booked out through March. So delaying a task force hearing, a committee hearing for a month won't delay a full task force hearing in any bid.
I mean, I really think for good practice, we should have the full packet before us here in case there are things to go through. I know sending partial packets onto the full task force is something we've been trying to avoid because as it is, full task force hearings have been going on so long. And so we run the risk of this being an extended hearing otherwise.
Well, I'm going to say
something.
I'm split on this, but what I would like to do is with any kind of resolution, any matter, I want to excuse the complainant from having to appear at a continued hearing because I think that it's my thought that it would be just wrong that we could move this forward and the complainant would have to appear again when they were all prepared to do what we asked them to do here today. And so even if we move this and we allow the DA to make an appearance, I would like to make it optional and tell Ms. Avalos that Ms. Avalos has done what is needed from Ms. Avalos. But that's just sort of my detail on my thoughts on this, because I'm mixed about whether I'm even very intrigued by Member Stein's comment that why don't we just send this to the task force anyway? We sort of know enough. What else do we need to know that it's going to go there anyway? Mm-hmm. But that's not a motion. I'm not making the motion because I don't know what we want to do here.
Yeah, I guess I'm still leaning on why delay it further, and also I had in my mind too this issue of asking the petitioner to come back they're spending hours of their time doing what we've asked them to do, and then just, holding it over and, sort of redoing this next month. When, it's either that we're not going to have information from them and it's going to go forward like that, or we're going to have information from them and it's probably going to go forward like that. I mean, everything pretty much goes forward. We're just kind of trying to screen it to make sure that everything that needs to be there is there, but it doesn't always happen that way anyway.
This is Member Yankee. I would absolutely agree with Chair Schmidt that if we do continue this, I would absolutely consider that the petitioner's attendance requirement has been met, and if she wants to return for a future date, she's more than welcome, but by no means required whatsoever, because you're absolutely right that she's met her requirement. And the last thing we should do is impose additional, meeting requirements on her. At the same token, I'm still, there's a part of me that wants to make sure we go through the due process, and I don't think that was done here. I don't think that the district attorneys had the ability to appear or submit written documentation. And even though the end result might be that it ends up going to task force and likely will, I just don't think it follows giving each side the fair and equal shot of appearing before the committee. And so I'm uncomfortable doing so. So, I mean, I'm more inclined to continue it, but have the petitioner's attendance at that continued hearing be optional.
Okay.
Yeah, I hear you. I understand, and I completely understand what you're saying, but I guess I feel like the due process and the real decision-making process is what happens at the full hearing, and this is just a kind of pre-screening. So to me, it's not like anyone's really being denied due process. They will have due process at the full hearing.
And on the due process issue, I think there is a process that's been set up within the rules of the task force, and maybe people have an expectation, but I don't know if I'm seeing that a party who is given a full hearing before the task force can say, well, they also had a due process right to a committee hearing. I can't see that as being, per se a due process issue. To me, it's a process issue. But
my concern, Chair Schmidt, would be that there's been more opportunity for one side to present to members of the task force than the other. At the end of the day, if you calculate all their time, one side's been afforded more time than the other has because of an administrative error. And so inherently, I think there's an unfair aspect to that. As much as I absolutely regret, the administrative error, and I think that's, we shouldn't have to be in this position, and I would absolutely apologize to the petitioner for that. At the end of the day, I just don't think it's particularly fair that one side gets the opportunity to make a longer presentation to the other, even if it's to a subset of the task force members. At the end of the day, if we go into the full hearing, Member Stein and myself will have heard from the petitioner more than we've been able to hear from the district attorney's office and their representative. And so I think that is a certain due process issue. I mean, unless we say that, hey, we heard from, 5 minutes was just given to the petitioner here, so we're going to give the 5 minutes carried over plus an additional 5 minutes, right? Then maybe that would make it even. But otherwise, no, I think there is a due process issue. Not to belabor the point.
I'm fine with giving them an extra 5 minutes at the full hearing. I understand I do get why this is like a little bit complicated, but I actually think they're still going to get, we're all going to read whatever they submit. We're all going to hear what they have to say. If they feel like they missed out on 2 minutes in this subcommittee hearing, they can have an extra 2 minutes. Like, really, we've only heard from the petitioner for 1 minute. And otherwise, we've just read her materials, and we're going to read them again along with whatever other materials are submitted by the respondent.
Is it possible to ask a question?
Yes, please.
Would the district attorney have known this process, this notice of hearing and this process on submitting documentation within 5 days? Are they familiar with it? Or the petitioner is new to this?
Well, I'll just attempt my own, this is Chair Schmidt, my own answer to that, which is that, yeah, the district attorney's office is very familiar with these rules. And so they may have a process where they would only calendar this if they got the notice of it, and technically they didn't get the initial notice. So there is an argument to be made that they did not expect to have to be here today because the notice didn't go out properly.
Okay,
and that's sort of part of what we're sort of going back and forth over. I mean, you know, I think we all have good points on this. I think all of the people who've talked about this, it's just somewhat of a quandary. And yeah, go ahead. Sorry.
I just wanted to raise one other issue and maybe ask a question of the petitioner. Is that on the one hand, I like Member Yankee's suggestion that we wouldn't require the petitioner to come back for the next subcommittee hearing because they've met their requirement to appear to have it heard. But on the other hand, I feel like if there is then a discussion and the respondent is there and the petitioner is not there, the petitioner may be at a disadvantage in not being able to reply to things that the respondent says or answer questions that arise. And so in a way, I feel like if I were the petitioner, I would feel like I had to come back. And so I guess the question for the petitioner I have is, you know, how do you feel about it? Like, would it be a big inconvenience on your time? Would you feel uncomfortable not being there? What is your perspective on that?
Can you hear me?
Yes.
That's a really good point. I would want to be there. I am 2 hours ahead in Central Standard Time, so you know, I would hope to be there. That way, I could respond to any questions or concerns.
Since you are Central Standard Time, Ms. Avalos, we can see to it that you're first on the agenda so that you are not penalized by the late hour that this would be for you.
Okay,
Absolutely.
I appreciate it, and I understand completely. Thank you.
Absolutely.
All right. Then I guess I would be okay with postponing it if the petitioner can go first and it doesn't, you know, waste any more of her time.
Yeah, and I'm hesitant. I mean, I think that for this case, it's important that we sort of try to figure out how to deal with this, because I can imagine this would happen in other cases. And I tend to be somewhat where Member Stein is, which is, well, you know, how would it change things if the DA got to appear in these circumstances? I don't know how much it changes things, but that's sort of more about our processes than about how we treat the parties. And so, yeah, maybe we should just come up with a motion to move this thing forward and we make it optional for the complainant. I'll make the motion. We continue this to the next complaint committee hearing. It's optional for the complainant to appear because the complainant did appear here today. But it will be set at the front of the calendar, and then we will have an opportunity to hear from the DA on this matter. That's my motion.
I will second that. This is Member Yankee. I think that's fair.
Okay. So let's go ahead and see if we have public comment.
Anonymous number 3.
Sullivan.
All right, we have Anonymous 3 and Sullivan is here. So we have 2.
Okay, Anonymous number 3, do you want to go first?
Sure.
You may begin.
Thank you. This is Anonymous number 3. I don't think you even know that the DA's office has received notice of the complaint. And the reason I say that is if you can't find it in the sent or the outbox, it's possible that the email was only partially sent, in the sense that the transmission to Ms. Ovalis succeeded, but the transmissions to the DA's office never actually succeeded, which is why there's no date timestamp and why it's possible Ms. Leger can't find her own copy in the SOTF mailbox. So I think you should also, as part of this, make sure that you've freshly, correctly noticed the DA's office. And it is the case that there are 3 different notices usually sent by SOTF to the parties. The first is the service of the complaint, which has no date for when the hearing would be. Then there's another one that says you have N days to submit supplemental documentation. And then there is the one with the agenda packet. But if they've never received the first 2, I agree that there's no way they could have known to do anything correctly here. I would suggest that since you are doing this under the new pilot procedures, you send them the new instructions, and you might see that it might facilitate a quicker resolution of this kind of case, because this is the exact kind of case where they might say, yeah, sorry, we didn't hear the records, and you can maybe consent calendar a ruling against them, and she gets the record she wants. Maybe. But that is an option under your new pilot respondent packet procedures. So I'd suggest that you fully renotice the DA's office with your new instructions. Thank you.
Thank you. When Cheryl's ready, we can hear from Sullivan.
Mr. Sullivan, are you ready?
Yes.
Go ahead, sir.
So I don't disagree with this motion, but I do agree with Member Stein. I think that if they had been properly noticed and they hadn't appeared, I think it would have been fine to move it on to the full task force, especially with such a fairly simple complaint. I mean, it only took her 1 minute to tell what the complaint was. They haven't responded at all to her complaint, and that already is a violation, whether they're going to cite exemption for all the records or they're going to state that there are no records. So they've already violated. And the respondent can submit information on this complaint at any time up until 5 days before any hearing. So they don't have to wait until they get. All right. Thank you.
Thank you. All right. I don't think we have any other public commenters on this matter, so let's go ahead with our vote.
Chair Schmidt?
Aye.
Chair Schmidt, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Stein?
Aye.
Member Stein, aye. Moved by Chair Schmidt, seconded by Member Yankee to continue the matter to the next complaint committee hearing. And note that it is optional for the petitioner to appear and that her matter will be set at the beginning of the calendar.
Okay, that's the end of our 3 cases tonight, and so we can move to the proposal, which is number 7. When you're ready, Cheryl.
Item number 7, proposal to improve complaint files. Items that were submitted by Member Stein.
And I would say that we should just. I'm going to hand this over to Member Stein. This is all done by Member Stein.
Okay. Yeah. So basically, This came about because we were looking for ways to make the packets more relevant and streamlined. I tried to put my rationale for all of the suggested changes that are proposed here into the document itself. There was several appendices that get specific about the wording of changes, but I will note that what I submitted had been edited in Word files and in color, and then they got printed out and rescanned, and it's not quite as much, like some of the information was lost of the original files that I submitted when they were printed and turned into a PDF, which actually kind of also speaks to my last item on my proposal about thinking about moving forward with better uses of technology in the future. But basically, what I tried to do was take the discussions that we'd had earlier and any input that was given to me by members of the public and by other committee members in relation to any of these items and try to synthesize it into a set of concrete changes. I will say I also reached out to the clerks at the Board of Supervisors to try to get their input on this, and they were actually the ones who kind of directed me to think about rewording our guidelines somewhat as well, to try to make the packets more relevant just through the instructions that we give. So I ended up with, sort of 3 different kind of approaches to trying to make the packets more relevant, and it involved guideline revisions, some structural revisions to how the packets are presented, and then also technological revisions. And I will say, the administrators were also part of these discussions. And so I just tried to put something down that we could, say works or doesn't work in various respects. I did have a conversation with Chair Schmidt about whether to try to break this up into different proposals, because it's a little bit long and maybe it's a lot to kind of hash through, but here it is, and I would love to hear people's thoughts on it.
Okay, thank you. Anything from member or Vice Chair Yankee?
I think it looks fantastic. I think this is just great work that you did, Member Stein. Really don't have anything to add to it except thank you for your work and actually putting all this down into a written format. I think it really does help streamline things and gets to the issue of I guess, to even a certain extent, what we're seeing tonight, and anything we can do to decrease administrative or other types of errors or confusion ahead of time and help streamline the cases so that they're more ready to be heard and everything's there that we need it to be, I think is really going to help, particularly with the backlog that we have. If we can, decrease the amount of time we spend for each file by keeping it in a probably better organized fashion, I think is just going to help, not only the task force members, but members of the public with getting their cases heard more quickly. So I'm fully supportive of all of this.
Okay, that's great. Well, I would love to hear public comment on it.
So, yeah, I pretty much, I think this is great. I think it's definitely ready to be put before the full task force. It's a very worthy project, and I appreciate all the time that Member Stein put into it. I think that I had a couple of things that are fairly minor that probably could just be put out there when we move it on. I think the substance is already ready, if you ask me. And the structure of it is good to me. So I'll leave it at that. Yeah, and I think that yeah, those are my comments on it.
Okay.
Yeah.
Go ahead. Yeah. Cheryl, did you have a comment?
I could just hear you typing. So I want to
Oh,
hear.
sorry. Yeah, I'm just trying to take some notes. I will say the process of doing this, I just want to give this feedback, was a little bit frustrating because it had to be done in the public meetings. And I just sort of got people's comments, and then I felt like because of the way we structure our task force, I couldn't really, have any side discussions with anybody. Like, does this make sense? Is this okay? Would this be right or wrong? And so I kind of felt a little bit like I don't want to say flying blind, but I was really kind of like on my own, except for these, very structured situations where I could get like a little bit of public feedback here or there. So I wasn't sure if I came today, if people would say, oh my gosh, you can't do this, you can't do that, this is, whatever, because I felt like I was really kind of on my own trying to put it together. But I hope that it kind of reflects where people think things need to go. So I would love to move forward and hear public comment on it.
Thank you. Thank you. Let's see. I guess we probably should just move it or propose to move it forward. What we might want to do is have a motion to send it to the task force. And so I'll make that motion. And then, of course, there could be something from the public that, it may change things up. But at least if we have a motion out there, I'll make that motion to move it forward to the task force as is.
Okay.
Do we have a second?
This is Member Yankee. I will second that.
Do we have public comment, Schmidt?
Yes, let's go ahead with public comments. Anyone on this public comment on this matter? Sullivan. Number 1, Sullivan. Anonymous 3, number 2.
Do we have other public comments?
Yeah. Okay, yeah, it sounds like we're ready for you, Mr. Sullivan.
Just a second. Mr. Sullivan, are you ready?
Yes.
Go ahead, sir.
So I'm all for streamlining. I want to just talk about one thing. So currently you want to revise Section D on reconsideration to that verification that these materials were not available. Currently the word is exist. And if you are changing that word available, I would change it to presented. That verification that these materials were not presented. I've heard a number of illogical arguments using available in this context. One is if any information was available before, but not presented at the hearing, then the reconsideration should not be heard, regardless of when it becomes known or regarded as important. Is SOTF saying a complainant must know all that exists somewhere in the world before filing a complaint? If this is true, that would mean only new information created after a hearing, but within 90 days of an order of determination would be considered on a retroactive basis for reconsideration. The use of available creates convoluted, illogical arguments. Consistent with the language and spirit of the San Francisco Sunshine Ordinance to provide the most open government possible, all inferences, that means the logical arguments and evidence, shall be viewed in light most favorable to the petitioner. The fact is, complainants want to represent their best case the first time around with all the information that supports their complaint. They also have no idea what issues may arise during a hearing or information required that was not presented. The most important thing for the SOTF is to make the correct decision based on the law and all the information presented to them. If new information is presented to SOTF, that would change their decision from a previous decision. You should hear it. You do not want to perpetuate or make stone a flawed decision. Thank you for your time.
Thank you. All right. Now, when Cheryl's ready, we can hear from Anonymous 3.
Anonymous, you ready?
Yes, I am.
Go ahead, sir.
Thank you very much. This is anonymous number 3. First, I had a question. It seems like the only material change to how the process works is, in fact, the request for reconsideration process that was just discussed, and the rest seems like a better explanation in plain English of exactly what you're doing. And I would hope, please correct me if I'm wrong, if you're actually changing something materially in the rest of the process. I didn't catch that in these revisions. The second thing is I think they're great. I think it's a much better explanation. Thank you to Member Stein for doing this. The part about what Member Stein was discussing right at the beginning, where, well, by creating this in printed and scanned in black and white took away information, that's still the case for complaint files. I don't see that given a lot of attention other than the Granicus dispute, but I know when I insist, the staff does keep my complaints in that exact copy digital form, and I'm not really sure why that can't be done for everyone. I just don't understand what the point of a city agency printing everything out that you get digitally and then scanning it back in is ever, and especially not when you're using that as evidence for what your complaint stands for. And I understand that this suggestion says, well, first figure out what's going on with Granicus, but I don't see why that should prevent just keeping agenda packets in a digital form instead of in a physical form, whether that's a complaint or whatever else. They really should be kept in a digital form. Otherwise, you're not technically looking at the evidence we submitted. You're looking at this degraded version of our evidence. Thank you.
Thank you. Thank you.
Can I just respond?
Okay.
Can I just respond to question
please.
that was presented by Anonymous 3, which is, as I understand it, I don't believe that I am changing anything else materially. Most of what I'm doing there is just trying to, make it easier to understand what we're looking for and to sort of reduce redundancy and, as you say, put things into plain language. So my intention was not to materially change the instructions that we have.
Okay, and just a response to Member Stein, where you said, geez, this is, it's an odd process because it's sort of like the kind of thing that would be co-drafted. And so you get people to sit down at a table and knock things out, et cetera. We can't do it that way. And that's fine. But I'm sort of assuming that when it goes to the full task force, you'll make the proposal, and it may be that members and members of the public can take single items and suggest changes, and then maybe we either make changes there or we go back to the drawing board. I don't know, but this is just a weird process, but we're moving it forward, and I think that's that's the essence of the motion here. Is I think it's it's clearly good enough to put for the task force to go to the next step in the process.
Okay.
So I think if the members are okay with it, let's go ahead and vote.
I'm okay with it.
Member Schmidt? Chair
Aye.
Schmidt?
Aye.
Chair Schmidt, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Stein?
Aye.
Member Stein, aye. Moved by Chair Schmidt, seconded by Member Yankee to send the task force, send the packet to the task force. Okay.
Then when you're ready, Cheryl, we can move to the next item.
Item number 8, announcements, comments, questions, and future agenda items by members of the complaint committee.
Okay. Unless either of the members has a urgent item, I do want to say that I feel like we've had a couple of meetings lately where we just haven't gotten a lot of cases resolved. And I have been, every month I ask Cheryl for more, and I know she adds cases on, but cases will resolve or settle, etc. But it may have already been evident, but the backlog just really is concerning to me. And so I'm hoping that we can get more to come to the pipeline. I don't know exactly. I'm not really in the process of how the cases come to us. So far, I just ask for more. The other item I have is that I have been in looking at Member Stein's proposal. I noticed there was a portion of one of the documents where she really didn't make edits to it, and so I didn't make too many comments about that. But that's the complaint procedure itself, and yet I myself have some ideas about making changes to the complaint procedure, especially in light of the numbers of our backlog. And I know that other attempts are being made to attack, I'll call it attack the backlog, and I certainly appreciate that. But I'm hoping that I can come up with a proposal of my own with regards to backlog and some alterations to the complaint procedure. But I've been holding off on that because I wanted to make sure we got through getting Member Stein's proposal out of our committee. And so there we go. That's where I'm at. And that's my announcements.
Can I say something to address
Yeah.
Yeah. We do get an average of about 10 new cases a month. Several of them are anonymous. And as you know, we are putting a priority on requests that are made by individuals, members of the public, other than anonymous. And I just also want to point out that EOT is also listening to cases. They just had 5 heard last week. And so we're chipping away, maybe not as quickly as you would want, but as they come in, Victor and I develop summaries and send the complaints out. And when we get responses, that's when we try to put it on the calendar. So as Member Yankee is also aware, Victor developed a chart for Chair Wolf that identifies cases that are ready to be heard. And as he said, we are through to the beginning. We have selected cases through to the beginning of March that we have suggested to Chair Wolf. And this also is that we are also looking to not have another meeting go to 1 o'clock in the morning. I know we had at our last task force meeting, we probably had 8 cases, and that's a lot. And one of those cases was not heard, but that's a lot. And that was till, 10:30 right there. And that didn't include the consent calendar and a few other things. My administrator's report, I really didn't have a chance to talk about it, but we're doing what we can to address this issue. And as I said, Member Yankee is well aware of what we're working on. And if Administrator Young would like to add further comment, he certainly can.
Thank you, Cheryl. I appreciate what you're telling me, and I don't necessarily think that any of these things can be like. There's no magic potion to this. I don't know if I necessarily have any great ideas, but I do, want to try to contribute any ideas I may have to figure out, what we can do on this. And I know that there's certain requirements which have, the process, cases aren't ready if they're not ready. And so, we only got what we got tonight. And yeah, it's good. EOTC is hearing things. No question about that. Yeah.
So Cheryl,
but that's just, yeah. Okay. That's all I needed to say there. Member Stein and then Victor.
Oh, so I just wanted to ask, so Cheryl, are you saying that like basically everything that was ready to be sort of pre-heard in committee this week or this month has gone out to committees? There's nothing like that's ready to be sort of looked at that hasn't gone out?
I can answer that. This is Victor Young. We do have a large list of items that are still pending committee hearing. I'm not sure how many, but it's in the 20-30 range and maybe higher. But then that's the one backlog, but then we have the other backlog at the full task force,
right,
where they can only hear about 5 a month.
Mm-hmm.
So we have 3 committees feeding the full task force, but the committees are feeding much faster than the full task force can hear them.
Oh, I get it. Okay. Yeah, because I was going to say, I mean, I do appreciate then being given the materials to kind of screen and look at for thinking about, how they need to go to the task force kind of closer to when they do go, because then it's also more fresh in my mind when I have to review it again at the full task force. But I had the same thought when I looked at this week's packet. I just thought, oh, this is a little bit light compared to what we normally see. But that being said, I am absolutely not a fan of meetings that go for more than 8 hours and into the wee hours of the night. And I personally feel like after about 8 hours, because everything requires such a high degree of concentration, it gets, for me, very degraded after 8 hours of sitting there and trying to kind of go through those materials. Yeah.
Yes. Let me. I'm going to hold off because Victor just spoke, but he may have something else he wants to say. But member Yankee, I want to give him a chance right now.
Okay.
Yeah, just to piggyback on to what Victor said, I was just looking at the last administrator's report from the last meeting. There's something like 49 that were still pending full task force hearings. So ultimately, the real adjudication takes place at the full task force. Mm-hmm. And so even if as Victor stated, we could pump a lot through the committee level, it's still going to hit another roadblock before they actually get resolved. I think the only way we're going to be able to solve this backlog is to somehow be able to increase the amount of cases that get adjudicated at a committee hearing. And I absolutely 100% agree with the sentiments that have been raised that staying till 1 a.m. I don't think is a productive way to do that. So in my mind, I keep thinking about what can we do to spend less time per case. And that might be some of the consent agenda. There might be other ideas. I mean, certainly I think also as Chair Schmidt pointed out, I don't think there is one magic bullet to it. But if we're having 10 on average cases come in a month, and the full task force can only adjudicate 5 per month at the meeting, that means every single month that goes by, the backlog's actually growing by 5 cases, right? That's just the math of it. So until we can get the full task force to adjudicate, let's say 10 cases per month, that's just going to be, stopping the backlog from increasing at that point, right? We'd actually have to be able to adjudicate over 10 cases per month to start making an actual dent into the backlog and shrinking it, right? And so I think that's kind of, at least when I try to think about how we do it, how my focus is, what can we do to expedite the number of cases heard per meeting? Because I think we've tried just throwing more on the agenda, and that just leads to late meetings, and I think you're absolutely right, Member Stein. You know, I don't think any. I know for me personally, I'm not thinking as clearly at midnight as I am at 5 p.m. when it starts, and I don't think that's fair to the petitioners, the complainants, the members of the public who have to stay up till midnight to have. I mean, it seems odd that we're supposed to have open government, and yet we're requiring members of the public to attend a midnight meeting to experience open government. That just seems on its face to make no sense at all. Why? That's not when government takes place at midnight. I mean, if we told people they had to go to the post office at midnight, we'd say that's not open government. You need open during, reasonable hours, right? So I just think we need to figure out a way to somehow streamline these. And I know that there's a lot of sentiment around, the hearings and the back and forth and the 5 minutes and this, that, and the other thing. But the more time we spend per case, that's just less cases we can hear. So I mean, it's a balancing act. There's something has to give somewhere, right? And it's just trying to strike that balance somewhere. So
yeah, can I just say too, when I did this proposal, I was really just focused, even though I changed some of the wording and tried to clarify what we're asking for in the complaints process, my whole focus was trying to improve the state of the packets. But I think there's real room for looking at the process. And so I would really welcome Chair Schmidt taking a look at that. And I think maybe even extending that to how are the hearings held themselves? And should there be time limits on, the amount of questions one member can ask, or the amount of time we spend hearing a case, something that would require us to kind of focus and tighten up how we approach each case, maybe down, focused on its most essential elements, something like that, because that seems like also part of the problem.
Yeah, it definitely. I mean, we could do this different ways. I just know that, I'm watching what Member Stein just did, and I think, well, maybe I'll throw some things out there, see if they stick. But, anyone with good ideas that can get support, let's say, get other people who say, oh, yeah, that's a good idea. We need them, because the numbers, just like Member Yankee says, the numbers aren't working right now. And, I don't know what all the reasons are, but it's like this, the numbers are just going up. And so we got to do what we can do. Yeah.
Just to clarify one thing, last year we ended our complaints at, just trying to take a look at my complaint chart. And last year, at December 18, we had 142 complaints. And that was the last complaint of 2020. And this year, we're at 150, and it's the second week in November. So we've got probably another month where we'll get, hopefully we don't because of the holidays, we may get another 10 to 15 cases. Just so that you guys know.
Thank you, Cheryl. Yeah. Go ahead.
And so for this week, I sent out notice to respondents for 7 different cases. So people are getting notice, and despite what happened with Claudia Avela's case, people are getting noticed. Respondents are getting noticed, so we're up to date on that. We closed probably 2 cases this week alone, one of which was supposed to be heard tonight, but it was closed. So that's kind of where we stand. We have, I mean, we're typical. I'm just letting you know where we stand with stuff.
Thank you, Cheryl. Yeah, the numbers are very important to watch, because any increases in the numbers, it's like, well, how do we respond to that? It's hard. Because our resources they seem quite limited. Okay. I know I put Victor off. Victor, did you have anything to add?
Not really. I think everything's been covered. We are getting a lot more in than we can handle with our current system, and we need to develop some methodologies. One suggestion that we did years ago was authorize the committee to make final decisions, but we got away from that. Try to do more work at committee level, and the simpler cases could be heard by committee and decided at the committee level. But that is a bigger discussion depending on the feelings of the task force at this point in time.
Yeah, and those are ideas that may need to be considered, because I don't think that doing nothing is really going to work here. So whatever it is we do, I think something's got to change in some various ways, including the attempts that are being made by the chair, the vice chair, working with Anonymous, working with Cheryl, and trying to get this project going that is going to cut some of these cases out. Absolutely. Okay, thanks, Victor. If there's anything else other than that, we can go ahead to see if there's any public comment on this.
Sounds good.
Okay.
Anonymous member 3.
We have Anonymous 3. Sullivan is up second.
Mr. Sullivan is speaking?
He'll go second. Anonymous 3 is first.
I didn't hear him say he was going to make a public comment. Mr. Sullivan, did you plan to make public comment?
Yes, after Anonymous 3 or before, it doesn't matter to me.
Let's hear Anonymous 3 first. I did hear him.
All right, you ready, sir?
Yes, I am.
Go ahead.
Thank you very much. This is Anonymous number 3. A few things about that. I've actually switched to using the Ethics Commission to file some of probably about a half of my Sunshine complaints, but and I think it may be the next speaker, my understanding is you file it through Ethics. Ethics is just going to say, yep, we found the violation and refer it back to SOTF. At least I think they did that so in Mr. Sullivan's cases. So I'm not really sure how using a different, one of the other methods in the city is actually going to help. Because unfortunately, the Ethics Commission will likely say, well, we don't think any of these violations, because I think they have never, ever found that any violation is willful, and then they will make a referral back to the SOTF. I've also had a communication about anything else I can put on the consent calendar, but I have to tell you, at this point, you have now considered, I believe, all of my kind of standardized audit of the entire city, and the remaining complaints, at least for me, a lot of them are related to the corruption probes, and I can tell you no one is going to consent to anything I can only assume, kind of admit anything in any of those complaints. And I'm not really sure how you would deal with those. I would suggest you use your ability to combine complaints, right? If I have N different complaints about the city attorney's office, I don't see any reason that you can't combine them. I also think that you should have more of it be based on written submissions. I know what Mr. Member Neighbors has said, that not everyone can submit written submissions. Some of us definitely can, and the respondents certainly can, since they have staff and attorneys to do so. And that might cut down your time, because it's not just, by the way, an initial hearing and a full hearing. Some of my complaints, and you'll see Mr. Hooper's complaints, they're on their 6th hearing now, because they keep on going back between initial committee, full task force, compliance, full task force again, something changes again, back to compliance. I think some of Mr. Hooper's are now on possibly the 8th or 9th at compliance. And agencies that don't comply, I think you should be able to use exactly what the Sunshine Ordinance says. You should never hold more than 2 hearings, if that. If you find the violation, you have the authority under Admin Code 67.30 to simply refer them to the Ethics Commission and the District Attorney. And you should not need to spend endless more hearings once you have found it. once you have found that the city is violating the law does not require you to give them endless more bites at the apple. Please refer them to enforcement as soon as you find them in violation, as 67.30 states. Thank you.
Great. Thank you. Thank you. And now we'll hear when Cheryl's ready from Sullivan.
Mr. Sullivan, you ready?
Yes.
Go ahead, sir.
So I agree with all what Anonymous just said. And beyond this, beyond the city complying better with sunshine ordinance, which would reduce your complaints, the number one thing that's holding you back is your procedures. And the sunshine ordinance itself allows you a great variety from you may hold the hearing to holding hearings. And you don't even have to, as Mr. Young said, require in front of every, the simple complaints to be heard in front of the full task force. They could be held in committee. The only problem with that is that you have the 6-vote requirement, and your committees only have 2 or 3 members. But I don't think that 6-vote requirement is. I don't think you should have to comply with that. I won't go into that. And I do agree that you're as soon as you're complained, you find a violation, you should send it to the for enforcement, either to the ethics commission or to the district attorneys or city or whatever the other thing is. That's all I have to say. Thank you.
Thank you. I believe that's the end of public comment, and so we can move on to the next item.
Item number 9, adjournment. I have 8:07.
Great.
Before we
yeah.
do that, I want to apologize to the committee and the complainants and the respondents for not paying better attention to my duties here as a task force administrator. I didn't mean to embarrass the committee. It wasn't my intention. I thought that I had provided the district attorney's office with a notice of the hearing. I guess I didn't. So please accept my apologies.
I completely understood, Cheryl. It's these things certainly they will happen. Yeah, I understand it. Yeah, it's part of the process. Will break down sometimes. Understood. Right. Yeah.
So who moves to adjourn?
Yeah, I'll move to adjourn.
I feel like I'm always the one moving to adjourn. So.
I'll take a turn at it.
Laurie, you second?
I'll second it, yeah.
All right. Thank you very much. I will stop the recording.
Thank
Good
you,
night, everyone.
Yeah, thanks, everyone.
Thanks.
Everyone.
Take care.